Thank you so much for having me. It's such a pleasure to be here. Um, it means a lot that I can speak at this conference today, and I hope in turn that what I will tell you will mean something to you. So in September, my colleagues and I completed our legal clinic that we had started about 1 year before with Adamir, Prisoner Support and Human Rights Association. They had given us the assignment to research the international criminal liability of judges in military courts, following from their complicity in the war crimes and crimes against humanity, of torture and ill treatment of the Palestinian detainees. We were very lucky to receive such a very specific research question. And we could also rely on their thoroughly researched reports on the situation in Palestine, as well as the testimonies that they provided us with from the lived experiences of the Palestinian detainees. And they did all this despite facing constant limitations imposed by Israel and sanctions imposed by the United States. Our research group was made out of 5 people, so 4 students and our supervisor, Maha. And we found ourselves very lucky to be guided by such an expert during our research journey, because it was a learning process for us. Despite all of us, all of us were concerned with the Palestinian cause from the start, but I don't think any of us could have predicted the degree of complicity of the judges in the military courts in facilitating crimes against humanity and war crimes, nor how crucial their role proved to be in enforcing the occupation of Palestinian land and subjugating the Palestinian people. So, despite the important role of the military courts in enforcing the unlawful occupation, the question of individual accountability of the actors involved is largely overlooked, both in activism and in the literature. And that's why we wanted to address it, because of the necessity to not only hold accountable the main figures, such as the Prime Minister or the former Minister of Defense, but to have accountability at all levels. Because the settler colonialist apartheid regime and the unlawful occupation are held in place by many individual actors, and judges have a major role to play in this regard. The imposition of martial law in 1967 is to be understood as the continuation of a long-standing strategy of displacement, domination, and legal fragmentation. Today, the military court system, which has a conviction rate of 99% for Palestinian defendants, it serves as one of the central systems enforcing the occupation of Palestinian land and subjugating the people. Palestinians tried in Israeli military courts are systematically denied due process and fair trial guarantees through prolonged detention without charge or trial, or charges based on secret evidence, severely restricted access to counsel, and proceedings that are conducted in a language that many of them do not understand. Since 1967, Israel has imprisoned more than 800,000 Palestinians, which accounts for about 20% of the entire population and 40% of Palestinian men. And today, like colleague Khalida Jara just said as well, there are about 11,000 people, Palestinians held across prisons, detention facilities, and interrogation centers. Many of them are children. Many of these children are held in administrative detention without charge or trial. Since October 7th, 2023, between 75 and 81 Palestinians have died in detention, although the exact number still remains uncertain. And I'm telling you these numbers to illustrate how Palestinians in Israel's prisons and detention centers are experiencing a silent extermination campaign that is unfolding inside the prison cells away from the public eye, and that the military court system serves as a central actor for the demographic alteration of the occupied Palestinian territory. And it also serves to suppress the resistance or dissent by targeting organizations and individuals who oppose apartheid by depriving them of fundamental rights. So in order to argue that the judges' complicity in enforcing occupational policies amount to war crimes or crimes against humanity, we analyzed their position, their role, and their competences within the system. Judges in the military courts have the competence to decide whether or not someone is held in detention. They review the administrative detention orders issued by the military commander. The poor conditions of detention, the denial of medical care, and the widespread and systematic nature of physical, sexual, and psychological abuse have been documented for decades by United Nations bodies, by human rights organizations, by academia, by the media, as well as the judges' own court proceedings. But despite knowing that detainees are being tortured, judges in military courts continuously extend the detention periods for detainees. They also obstruct the documentation of torture by not enforcing the remittance of medical reports and pictures of tortured detainees, and by refusing petitions to challenge coerced confessions. So rather than acting as safeguards, they actively facilitate these abusive interrogation practices and detention conditions. And the complicity goes beyond judges serving in the military courts. Israel's Supreme Court, sitting as a High Court of Justice, is similarly implicated since it adjudicates all administrative decisions. And similarly, the court does not intervene proactively to put an end to the suffering of the Palestinian detainees. Instead, the court has aligned itself with the public prosecutor's policy on enforced disappearance. An example, in 2023, after human rights organizations submitted petitions to the court requesting information about the fate and whereabouts of several detainees, the court ruled that the Israeli authorities are under no obligation to share such information. It is common practice for the court to reject petitions for lawyers' visits, despite being confronted with clear evidence of torture on the victims' bodies, under the argument that such measures are necessary for national security. And so, the court effectively prevents lawyers from documenting the torture on their clients. It is important to see the interplay between the isolation of the detainees and the ill treatment that they face in detention. So, when a Palestinian person is arrested through Israel's practice of enforced disappearance, they vanish from the face of the earth, leaving their families behind, worrying about their whereabouts, their health, whether they are even alive. With restricted access to counsel, with the general prohibition of family visits, these detainees are isolated, placed outside of the protection of the law, and this creates the this creates the conditions for other human rights violations to occur, such as the torture and ill treatment. Finally, the Supreme Court of Israel has even provided legal cover for torture by the security services. This is a grave loophole within the Israeli judicial system that dates back to a judgment from 1999, which authorizes agents to use a necessity defense against criminal prosecution for the use of coercive interrogation practices. De facto, this means impunity for investigative measures that amount to torture or inhumane or degrading treatment. Judges may incur responsibility not only for their orders that actively facilitate the mistreatment of specific Palestinian detainees, but also for their positional contribution to the maintenance of an unlawful discriminatory regime whose continuation the International Court of Justice has explicitly ordered to end. In its advisory opinion, the ICJ has recognized that a broad array of legislation that is adopted and applied by Israel in its capacity as an occupying power treat Palestinians differently on prohibited ground, and that this differentiation in treatment is it cannot be justified. Basically, it means that the legal framework governing the Palestinians is recognized to be discriminatory. Moreover, the court has said that the continued presence of Israel on the occupied Palestinian territory is unlawful, and that therefore Israel has the obligation to withdraw from the territory as rapidly as possible. Taking together the discriminatory legal framework as well as the obligation to withdraw from the territory as soon as possible, Israel also has an obligation to repeal all legislation and measures creating or maintaining the unlawful situation, including those that discriminate against the Palestinians and those measures that are aimed at modifying the demographic composition of the occupied territory. And thus, we argued in our final report that judges in Israel's military courts may incur international criminal liability for participating in a systemic practice of political and racial persecution, knowing their role advances the state's genocidal objectives. By legitimizing unlawful detention and ill treatment of detainees, judges in both the military courts and the High Court of Justice may be complicit in conduct that amounts to war crimes and crimes against humanity under the Rome Statute of the International Criminal Court, including persecution, willful deprivation of fair and regular trial, unlawful deportation or transfer or unlawful confinement, enforced disappearance, torture, rape, and other forms of sexual violence. Despite what you might expect, there are very few precedents in international criminal law that address the complicity of judges. Actually, we've only found one judgment that was relevant, one relevant precedent, and it's the United States v. Alstater case, which is a landmark decision before the military tribunal at Nuremberg. In Germany at the time, the entire justice system was transformed in order to further the state's policy of violence and genocide. Legal professionals enforced laws that enabled arbitrary detention, racial discrimination, and the execution of civilians, despite knowing of its illegality and inhumane purposes. Therefore, the tribunal at the time held that the judiciary who applied this discriminatory legal framework was individually responsible for its participation in this unjust system. Importantly, the tribunal created a very clear precedent. Judges and prosecutors were convicted not because they issued or executed individually unjust rulings, but because they participated in a systemic practice of political and racial persecution, knowing their role advanced the state's genocidal objectives. Similarly, today, judges in Israel's military courts, by continuing to adjudicate within this system, facilitate the denial of fundamental rights to Palestinians and thereby contribute to persecution as a crime against humanity. Persecution, how it is defined under international criminal law, refers to the targeting of individuals through the intentional and severe deprivation of fundamental rights by reason of their membership in a collectivity or a group. So it can encompass a broad range of physical, economic, and judicial acts that violate an individual's fundamental right to equal enjoyment of basic rights. Israel's unlawful occupation of the Palestinian territory and its establishment of an apartheid regime constitute precisely such a discriminatory deprivation of rights. The legitimizing and justifying of practices such as mass arrestation, arbitrary administrative detention, denial of fair trial rights, torture, and ill treatment, they all constitute severe deprivation of fundamental rights that are contrary to international law. And again, these acts are not isolated or incidental. They form part of a widespread and systematic attack against the civilian Palestinian population, carried out pursuant to a state policy of domination, supremacy, and demographic alteration of the occupied territory. The recently proposed death penalty that was approved in the first reading by the majority of the Knesset is yet another example of the discriminatory nature of the legal framework that applies to the Palestinians, as well as the legal entrenchment of this settler colonial apartheid regime. In violation of international law, the death sentence would be mandatory and non-commutable, which is especially concerning given the unfair nature of the trials held by these courts. And this death penalty bill did not occur in or not come into existence in a vacuum. It comes in the context of an oppressive and discriminatory legal system, as well as a drastic increase in the number of unlawful killings of Palestinians over the last decade, and the rise of deaths in custody since October 2023. And so the death penalty bill, it's yet another violation of the right to life of the Palestinian people. Now that I've given various grounds on which the judges could be held criminally liable, I do want to address the latent challenges that come with this proposal of accountability. As I said, we wanted to address it because the judges are crucial actors in enforcing the continued occupation of the territory and enforcement of the apartheid regime. But it's especially important to address because here in Europe, here in the West, Many still claim that Israel is the only democracy in the Middle East. And so it's important to emphasize that in Israel, the justice system has been created to further a state's policy of discrimination and genocide. The other reason we found it important to address the complicity of the judges is because of the few precedents regarding complicity, as I have mentioned. There's almost no precedents in international law, and so it would be an important development in how the ICC interacts with concepts such as complicity and persecution. Of course, the international criminal law and the ICC itself are subject of considerable debate and contention. Critical legal scholars have rightfully criticized the court. But at the same time, the ICC's activities are being heavily restricted these days, in line with a trend of repression and fascism that we have come together today to denounce. The imposition of sanctions against the ICC is a dangerous turning point in the history of international justice. And these are not isolated incidents, but deliberate attacks against the court aimed at weakening the rule of law and eroding faith in international institutions. And I think it has repercussions for justice everywhere, because if the ICC can be manipulated through financial coercion, no court or accountability mechanism in any country or region is safe. The United States sanctions targeted at ICC officials, at the United Nations Special Rapporteur of the occupied Palestinian territory, as well as numerous non-governmental organizations, including Al-Amir, for defending the rule of law and pursuing accountability. It's an attempt to shield Israel from accountability for its genocide against the Palestinians, the unlawful occupation of Palestine, and the apartheid regime imposed on all Palestinian people. As a student about to graduate, it's at times frightening to see how those that strive to uphold the international human rights system and international justice are no longer able to carry out their mandates without intimidation. I consider it to be characteristic of the times that academics and journalists are targeted for speaking out, facing at best resignation and at worst deportation or death, like the many journalists that are explicitly targeted in the Gaza Strip today. The reason why the settler colonialist apartheid regime has been able to continue for so long is because of the failure of the international community to intervene. The United Nations member states have failed to prevent genocide, allowing decades of unlawful occupation to continue. They have failed to take economic measures, continuously funding the genocide. And they have refused to comply with the ICC's arrest warrants. Similarly, the states have failed to act to stop the United States sanctions against the ICC. All of this, it's reprehensible because a failure to comply with international legal obligation leads to the erosion of the entire international legal system. And if Israel's violence is overlooked, it will become increasingly difficult in the future to hold states and war criminals, such as the judges, accountable. If we want a future with a healthy international legal order that can guarantee peace, we must not make exceptions for anyone. Thank you so much.